Report. Okay, fabulous.
All right, good morning, everyone, and thank you for being here. Jenny did a fabulous job of welcoming everyone to today's presentation, and I also just want to extend that welcome as well. So thank you all for being here. I'm excited to share what I can with everyone and answer any questions on HR topics. All right, can everyone see my screen all right?
Yes, we can.
Yes, we can.
All right. The start title 5-year HR compliance concerns for 20. Sorry, what's that? Okay. All right. So we'll get into just a very quick agenda for today. First up, I'm going to cover some national HR compliance items, and then we'll go into the state-specific and statewide compliance items. So. All right, so multi-state compliance is and has been, kind of a huge item since COVID. COVID really kind of opened up the world of hybrid and remote work. Not that it wasn't there previously or pre-COVID, but it definitely expanded and brought, kind of new opportunities. As Jenny was mentioning, one of her coworkers works from New Mexico. So it definitely opens up some opportunities, but also some compliance risks in that regard. You can see the statistics there. This is a recent Gallup survey from November of 2023 here. And even if you don't have remote employees, having employees in multiple locations can. Sorry, what's that? Okay. So having employees in multiple locations can, include an administrative burden of, not only sourcing workers' compensation, also state unemployment tax or SUTA, but it can also trigger state and city-specific laws and ordinances that companies need to be aware of and comply with. So, for example, I've recently had 2 clients that have been audited by the Bloomington paid earned sick and safe time laws, which thankfully they partnered with us and they were all in compliance, but it's just one of those things that if you don't have a good resource for knowing that information and if maybe your policies aren't up to date, it can create that additional liability. All right, employers can also run into issues if they have, we'll call her Wandering Wanda, who wants to spend, half of the year or a few months in the winter in sunny Florida working out of her RV, and then come up to Minnesota to take a look at our fall colors in the fall. And then for the rest of the year, she wants to go to Washington and visit family. So not only are we talking about 3 different states that we need to be aware of, bind work comp in, have unemployment insurance in, we also run into paid leave laws, which are eminent in Washington as well as Minnesota. In addition, we can run into issues with, her health insurance plan, just using some of the benefits that the company provides as they may not be in network anymore. And also, where do we send her W-2? So those are all things to be aware of and know for items and employees that may be wandering or working in different states. All right, coming down the pike, we also have some legislation affecting 1099 workers. So a new law is effective on March 11th, 2024 here with the 6-factor test. So an action item here is if you have 1099 workers or you utilize independent contractors for any reason, you're going to want to take a look at this new law. I have outlined here the 6 factors. Of course, there's room for interpretation in these. And of course, there's no, legislation or no litigation surrounding these. So at this point, what we can go on is what the law states. And other factors may be relevant if the worker is economically dependent upon the potential employer for work. Another item to be aware of globally here is the use of AI or artificial intelligence. Almost overnight, the use of AI has swept through businesses of all sizes. So there's 5 states that have enacted laws surrounding the use of AI in elections specifically, banning what's called deepfakes or images or video created by AI meant to influence the political campaign. So Minnesota is one of those states. California, Texas, Michigan, and Washington are the other 4 that have enacted those laws. Other states, Maryland, Illinois, and New York City, have laws on the use of AI in the workplace relating to job seekers and what that hiring process looks like. So the laws require that companies inform job seekers about their use of AI within the hiring process and seek and obtain that consent to proceed forward with the process. So if you haven't checked into AI at all, one thing to be aware of is that it can be used for a multitude of things, literally anything from writing memos to that hiring process to, you know, establishing company protocols, really, or at least starting that process. When used in the right way and you know, with good intention and coupled with human potential, you can create some real efficiencies within business by utilizing AI.
Ashley,
So an action step here would be to, yes.
I just wanted to let you know that instead of just showing like your slide, we're also seeing your notes on the next slide, just in case you want to change that. You're doing great.
Oh, thanks. Let's see. Wonder how. Does that change anything, or you still see both?
That's perfect, Ashley.
Okay. All right, great. So the use of AI in the workplace is only going to increase in the next few years. And if you haven't looked into AI yet, you know, go to Google, search ChatGPT or Microsoft Copilot, and at the risk of sounding like a magician, prepare to be amazed. It's pretty crazy. All right, so next up we have the Minnesota Earned Sick and Safe Time. I was fortunate enough to be asked to do a presentation on this a few months ago. Thank you, MMA, for allowing me this opportunity. But we did talk Earned Sick and Safe Time pretty extensively, but I wanted to recap it here because it is still pretty evident, and I'm still getting questions on it from clients, so I wanted to add it to the presentation so that, you know, anybody and everybody can have the information that might need it. So this was effective January 1, 2024 here, so just last month, but Minnesota became the 16th state to enact a paid leave law. Ours looks a little bit different than some other states for now. Minneapolis, St. Paul, Bloomington, and Duluth all have similar paid leave programs as well, or the Earned Sick and Safe Time program. One question I've gotten a lot is there a small business exception? And there is not. This applies to any business with 1 employee or more. So it affects all employees that are not covered by a CBA or a collective bargaining agreement in the building and construction industry. So how it works is employees earn 1 hour for every 30 hours worked, up to a maximum of 48 Earned Sick and Safe Time hours for the year, with a rollover of 80. And this applies to every employee, so full-time, part-time, temporary, on-call, seasonal, you name it. And they are eligible to begin earning this Earned Sick and Safe Time after working for the company for 80 hours. So if you haven't already, you're going to want to look at what your PTO policy is and determine if you want to go with a straight Earned Sick and Safe Time accrual, because the law does state that if you have an existing PTO policy, you can modify it to fit within the requirements as well. So there's a ton more I could talk on that topic, but since the law is in force already, I'm going to end it there. And if there's any specific questions, I'd be happy to address them. All right, and then effective January 1, 2026, Minnesota will also join other states who have a paid family leave in force. So the easiest way to think about this is kind of like unemployment insurance. both the employers and employees will pay into the Minnesota Paid Leave Program. It will be at a rate of 0.35% of wages for both the employer and the employee. And then what it allows is an employee can receive up to 12 weeks for a single qualifying event. So that means if someone, you know, has a baby, expands their family, they can receive up to 12 weeks of time off of work. And it will be paid by this Minnesota Paid Family Leave Program. It will not be paid at 100%, but it will be paid to some degree. The details are still kind of fuzzy at this time, I believe, because we're still a few years out. More information should be released as we get closer. Since we work in, you know, every state in the country, we've seen this happen in other states where states issues a paid leave law initiative, and oftentimes we see that get pushed back, or the timeline get pushed back. So at this time, it's effective January 1, 2026. That's what we know right now. One thing also to note is this does allow up to 20 weeks total if an employee has more than one qualifying event in a year. So for example, if someone has a baby, they get that 12 weeks to bond with their infant, and then say they break a leg, need surgery, that kind of thing, they would have up to 20 weeks total for those events. How it will work is employees will go online to apply for the program, apply to get paid, and the state will have, you know, back and forth from there. All right, moving on to the Minnesota Parenting and Parental Leave expansion. This also is in effect already, but I felt it was necessary to mention because it does provide some significant differences between what the law used to be and what it is now. So employees are immediately eligible upon hire for up to 12 weeks of unpaid time off. This used to be where employees had to work for an organization for a year. So now it's immediate. This applies to employers with one employee or more. This was previously 21. And employers must provide reasonable break time for employees to express breast milk. And employers may not reduce compensation for that time to express breast milk. This is a change as well. Employers used to be able to coincide an employee's break time with, you know, the pumping time, but employers can no longer do that. Employers are also required to inform employees about the pregnancy and accommodation rights upon hire and when asked to provide notice. So action step here is to make sure your handbook's up to date with the updated legal verbiage of what the law requires. The new law also amends the pregnancy accommodation to include more frequent or longer restroom breaks if needed, frequent or longer food and water breaks if needed, and reasonable accommodation. So what this means is they could provide a temporary leave of absence or a modification in their work schedule or job assignment. So maybe an employee has a standing position, they could ask for an accommodation to have a chair to be seated. The reasonable accommodation, so in theory, employers should accommodate that. In addition, the lactation space needs to be clean, private, and secure, and other than their work area. All right, in addition, pregnant employees are no longer required to obtain medical advice, and employers are no longer able to claim undue hardship for the following instances. So these include, you know, some of the things I just mentioned: more frequent or longer restroom, food or water breaks, feeding, limits on lifting up to 20 pounds, and then new are the temporary leaves of absence, modification in work schedule or job assignment, and then more frequent or longer breaks. So again, action step here is just to make sure your employee handbook, if you have one, it has the up-to-date verbiage for the Minnesota Parenting and Parental Leave Act. All right. Minnesota also banned asking employees or prospective employees about their historical pay. This was effective January 1. So employers can no longer require an applicant to disclose their pay history. So sometimes I would see on a company application, so this would be an application that a company would hand to an employee employee that would say, hey, I want to work for your company. Do you have an application I can fill out? So on that application, a lot of times I previously saw, last rate of pay for under the job history category. So no longer can we ask that. And just as a note, I don't have the exact figure off the top of my head, but there are several states that ban asking candidates what their historical pay is as well. So if you have employees outside of Minnesota, you'll want to look at what those state laws are too. This does not prohibit discussing salary expectations or discussing a range of what, where an employee would like to be. So basically, all it bans is asking on, your company application what their former pay was. So again, action steps is to take a look at your application and make sure it doesn't request, what an employee's former pay was or pay. I expect this also to continue into 2024 and beyond. I mentioned that a lot of states have this already, but I expect this to kind of become the norm. There's also a ban on non-compete agreements. This was effective July 1 in Minnesota. You can no longer utilize non-competition agreements. So if you have those or you're in the practice of using those, you're going to want to take a look at them and compare it with what the law now requires and make sure that the language that may have been prohibited is now removed. This does not ban non-solicitation agreements, non-disclosure agreements, and non-confidentiality agreements. Those are all still permissible. It's essentially just, competition between employers. So we can no longer ban an employee from working for a competitor. Another thing to note is this is not retroactive. So if you have employees that have signed non-competition agreements prior to July 1, those are still in force. And this is for all employees regardless of their rank or their wage within an organization. We have seen a few states, including North Dakota, prohibit or significantly restrict the use of non-compete agreements in recent years as well. This, I imagine, will likely continue as well. So I just wanted to outline some of the items that we help with. So we have a list here, and we help our clients understand these legal updates. We help them update their handbooks. We also track this earned sick and safe time and coincide it with their PTO policy if they have one to make sure that everything is compliant and up to date. I'm gonna, Allison, are you on the call still?
Yes, and I switched to my cell phone, so I'm wondering if my mic is any better from here.
Sounds great,
It sounds
Allison.
better, yeah.
Oh, perfect. Okay. Awesome. Yeah. So Pro, I'll just jump in. I'm the business consultant for Pro, and we're an MBiz partner of production work of, MMA, and also handle their workers' comp and payroll. So Ashley basically covered it, but she's being humble. She is one of the experts in HR that works on our team and has worked with all of our clients on updating them on all of these new laws, getting their handbooks updated. So yeah, I guess the pitch at the end is if there's anyone that's looking for any solutions, consult for the compliance employee handbook, or just, searching for some other options for payroll or workers' comp. We would love to talk to them too. So.
Thank you, Allison. All right, and I'm ready for questions if anyone has any.
Well, thank you so much, Ashley. I'm obviously not in the HR field, and all those changes I'm just like, wow, that is a lot for businesses to take on into the new year. So of the people that are joining us today, does anybody have any specific questions that they'd like to ask Ashley? And I will let you know if you don't feel comfortable asking, you can always type it in chat, and I can ask the question to Ashley.
I also have my email address here as well as Allison's, if anyone has any questions after the presentation here that they wanted to discuss or talk with us about, we're more than happy to answer those and get you what you need.
So Ashley, one question that I have is how much time did businesses have from when the law was enacted to like, so like I said, Pro Resources is our HR team. And so when I did my onboarding earlier this month, I saw all the new laws highlighted there. So I'm wondering how long people had to get that in place. I'm betting it wasn't long.
Yeah, it varies depending on the law, but it's usually not more than a handful of months.
Wow. Just amazing work. Well, it does not look like oh, yes, Ashley?
Oh, I was just gonna say, we're very fortunate to partner with MMA. I mean, you guys, for the manufacturing industry as well.
Wonderful. Well, I am not seeing any additional questions, Ashley. If people have questions, you can reach out directly to Ashley and Allison. I am going to stop recording.